Hi, I'm Andrew Thompson, your Indiana attorney. Today we're talking about what to do if you've been sued in the state of Indiana, or if you've received a summons on a lawsuit. I've been practicing law for 22 years, and in that time, along with representing many clients in Indiana, I've represented both individuals and companies from New York, California, Texas, Florida, and the majority of the other jurisdictions in the United States. Your first interaction with the legal system may well be when you've been served with a summons naming you as a party to litigation. It could be over a contract dispute, or real estate, or as an individual named in a divorce, or involving a probate or other matter. When this happens, what do you do? What's the time frame to consider, and where do you go? Let's look at the various component parts of responding to litigation and the time frames that you have to do so. First of all, there's an answer to the complaint. Generally, you have 20 days, or if you've been served a summons by mail, 23 days to respond to a complaint with an answer in Indiana. At the same time you file an answer, you'll also need to consider filing a counterclaim or cross-claim if necessary to preserve your own claims on the same transaction or legal matter that's before the court. A counterclaim or cross-claim generally is and often must be filed within the context of the answer itself. A counterclaim is made against the plaintiff who named you in the lawsuit, and a cross-claim brings in other defendants, third parties, into the lawsuit as well. At the time your answer is filed, you generally need to make a decision about demanding a trial by jury, if you will. In the case where money damages are at stake, or in many other situations, you're entitled to trial by jury of right if you prefer, instead of having your case tried to a judge, which is called a bench trial. In divorce cases and other cases that are considered in equity, you do not have a right to trial by jury, and so such an election cannot be made, and the case will be tried specifically to the judge. Once the initial pleadings in a case have been filed by each side, the process of discovery may begin. And the process of discovery generally entails interrogatories, requests for production of documents, sometimes requests for admissions by one party or another, perhaps some third-party discovery through subpoenas and other methodology, and depositions by oral testimony. From this brief overview, you can tell that there are many complex aspects to litigation when you've been sued in the state of Indiana. It's wise to consult with an attorney promptly after you receive a summons. If you've been sued in Indiana and need competent local counsel to assist you with your needs, please call the Thompson Law Office for a free initial consultation. You can reach us at 317-564-4976 or find us on the web at www.thompsonlaw-in.com.